Hello students and welcome to the lecture. So students, as we know that we are covering the emergency provisions, right? And basically these are the topics we have scheduled for the discussion under this particular series, like the introduction, like the national emergency, like the parliamentary approval and the duration, like the president's rule, like the financial emergency, like the criticism of the emergency provision. Okay? So these are the topics we have scheduled for the discussion under this particular series. We have finished so far the introduction part, national emergency, parliamentary approval and duration, what we have been discussing upon, president's rule, and the topics we are completely left with is the financial emergency and criticism of the emergency provision. So we will start from where we had left in the previous lecture. Okay. So as we know that the government by the power of 2, Article 356 and the Article 365. By the power of these two articles, the government could impose the president rule. Okay, we had discussed this thing. Now I'm going to ask you a very simple question, and the question is Article 356 stands for which emergency? Which type of emergency? Okay, you have 30 seconds to think and answer, then I will tell you the answer. Your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. So the correct answer is state emergency or constitutional emergency. Okay, and the article 365, article 365 basically stands for the president rule. Okay, remember this thing. So after finishing the initial discussion, now let's talk about what are the consequences of the president rule. The president rule acquires the following extraordinary powers when the president rule is imposed in the state. Why it is extraordinary powers? Because it basically changing the basic provisions of the constitution. Okay, that's why it is known as the extraordinary powers. Okay, so first thing, he can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. Okay, he can declare that the powers of the state legislature are to be exercised by the parliament. Thereafter, he can take all the necessary steps, including the suspension of the constitutional provisions relating to any body or authority in the state. Okay, first thing, that he could acquire the entire powers and the functions of the state government and the state governor or any other executive authority of the state. Thereafter, he can declare that whatsoever powers were exercising by the state legislature, now these powers will be transferred to the parliament. Okay, thereafter, he can take all other necessary steps, including the suspension of the constitutional provisions, okay, which are relating to any body or authority in the state. That's a clear cut thing. Okay. Therefore, when the president rule is imposed in a state, the president dismisses the state council of minister headed by the chief minister. Okay? Why? Because these are the immediate or direct executive class of the state government machinery. Okay? Thereafter, the state governor, on behalf of the president, carries on the state administration with the help of chief secretary of the state or advisors appointed by the president. Why? Because when the state council of ministers and the chief ministers, who were the immediate or the direct executive class, when they got suspended, it means now the state governor will having the power of them. All right, and he could alone not exercise his power. Okay, so what will happen, that either he will take the help of chief secretary or the advisors who would be appointed by the president of India. Okay, this is the reason why a proclamation under Article 356 is popularly known as the imposition of president's rule in a state. Why? Because right now president directly ruling the state. Okay. However, he has appointed the state governor as a representative. He has appointed the chief secretary and the advisors as a subordinate to the state governor. But ultimate control vested with him, with the president. All right. Further, the president either suspends or dissolves the state legislative assembly. Okay. The parliament passes the state legislative bills and the state budget, because right now these things could not be excised by the you can say normal conditions of the state legislatures, because they are dissolved or suspended. Okay, remember, state legislative councils okay, they could not be suspended. Only the legislature assembly will be suspended. Okay, thereafter, another thing which we could see here, when the state legislature is thus suspended or dissolved, what does it mean? That right now the state legislature is not in the functioning. Then what will happen? First thing we could see here, the parliament can delegate the power to make laws for the state to the president or to any other authority specified by him in this regard. Okay, it means that the legislature powers of the state, they could be transferred to the president or any other authority specified by the president in this regarding. Thereafter, the parliament, or in case of delegation, the president or any other specified authority can make laws conferring powers and imposing duties on the center or its officers and authorities. Okay, it means that center officers and authorities could also be impeded with the powers. Next step is, the president can authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending is sanctioned by the parliament. What does it mean? Like whenever the budget, you can say, presented in the legislatures. Okay, I will tell you about the process of the budget when we will having the discussion over the budget. Till then, just remember that state consolidated fund is basically the main bank account of the government from which they provide the money. All right. So suppose you could say the state was presenting the budget when they got dissolved. Then the parliament will have the power to make the laws on it. Okay, but right now we are assuming a condition that in the Lok Sabha, or you can say the Lok Sabha is not in the session. Then what will happen? The president having the power that he can authorize, okay, expenditure from the state consolidated fund, which is to be sanctioned by the parliament. Why? Because the parliament's house, Lok Sabha, is not in the session. All right. Thereafter, the president can promulgate, when the parliament is not in the session, ordinances from the governance of the state. Okay, like if some orders to be passed, so first thing is that the parliament will decide over the thing. But we are assuming that parliament is not in the session. Then basically the president will have the power that he could pass the ordinances regarding the governance of the state. Thereafter, it should be noted here that the president cannot assume to himself the powers vested in the concerned state high court or suspend the provisions of the constitutions relating to it. It means that state high court provisions could not be suspended. In other words, constitutional position, status, powers, and functions of the concerned state high court remain same even during the president's rule. Thereafter, we have the use of Article 356. Since 1950, the president rule has been imposed on more than 125 occasions, that is, on an average twice a year. Further, on a number of occasions, the president rule has been imposed in an arbitrary manner of political or personal reasons. Hence, the Article 356 has become one of the most controversial and most criticized provision of the Constitution. Okay, so about national emergency and the president rule, we had already discussed in the previous lecture, so I will just skip it. Okay, so now let's come here. For the first time, the president rule was imposed in the Punjab in 1951. Okay, remember the question could be asked in the examination like which is the first state in which the president rule was imposed for the first time. So the answer is Punjab in 1951. Thereafter, by now, almost all the states have been brought under the president rule once or twice or more. It means almost all the 28 states which existed in the India today, okay, all of these states once or twice had been come under the president rule. Thereafter, the details in this regard are given in table 2 at the end of the chapter. We will look at it. Thereafter, when general elections were held to the Lok Sabha in 1977, after the internal emergency, the ruling Congress party lost and Janata Party came to power. The new government headed by Morarji Desai, okay, who was the prime minister of that time, imposed president rule in the 9 states where the Congress party was in power on the ground that the assemblies in those states no longer represented the wishes of the electorate. It means that whatever the electorate did, or whatever the people choose the government, Morarji Desai government, you can say, alleged that the Congress party was not fulfilling it. When the Congress party returned to power in the 1980, it did the same in the 9 states on the same ground. It means that that was a war, some kind of political war between the Congress and the Janata Party. In 1992, the president rule was imposed in the 3 BJP ruled states like the states of Madhya Pradesh, Himachal Pradesh and the Rajasthan by the Congress party on the ground that they were not implementing sincerely the ban imposed by the center on the religious organizations. Okay. In a landmark judgment in a Bomay case 1994, the Supreme Court upheld the validity of this proclamation on the ground that secularism is the basic feature of the Constitution. Alright, it means that no ban could be imposed on the religious organizations because that will shows the state intention to you can say curtail the secularism provision. But the court did not uphold the validity of the imposition of president rule in Nagaland in 1988, Karnataka in 1989 and Meghalaya in 1991. Thereafter, Dr. B.R. Ambedkar, while replying to the critics of this provision in the Constituent Assembly, hoped that the drastic power conferred by the Article 356 would remain a dead letter and would be used only as a measure of last resort. And he observed the following thing. First thing, that the intervention of the center must be deemed to be barred because that would be an invasion on the sovereign authority of the province, state. Thereafter, this is a fundamental preposition which we must accept by reason of the fact that we have a federal constitution. Okay. Thereafter, that being so, if the center is to interfere in the administration of provincial affairs, it must be under some obligation which the constitution imposes upon the center. The proper thing we ought to expect is that such articles will never be called into operations and that they would remain a dead letter. If at all they are brought into operations. I hope the president who is endowed with this power will take proper precautions before actually suspending the administration of the province. Okay. However, the subsequent event shows that what was hoped to be a dead letter of the constitution has turned to be a deadly weapon against a number of state governments and the legislative assemblies. In this context, H.V. Kawant, a member of the Constituent Assembly, commented a decade ago that Dr. B.R. Ambedkar is dead and the articles are very much alive. Okay, so that was a, you can say, commentary to each other. After this, what is the scope of judicial review in the President rule? So basically, the 38 Amendment Act of 1975 made the satisfaction of the President in invoking Article 356 final and conclusive, which could not be challenged in any court or in any ground. It means that if the President is satisfied that the state is not working as per the Constitution, he could impose the President rule, and this decision could not be challenged in any court. Alright, but this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the president is not beyond the judicial review, which means that it could be challenged also. In Bombay case 1994, the following provisions have been laid down before the Supreme Court on imposition of the President rule in Article 356. Like, first, the presidential proclamation imposing President rule is subject to the judicial review. Thereafter, the satisfaction of the President must be based on relevant matter. The action of the President can be struck down by the court if it is based on irrelevant or extraneous grounds, or if it was found to be malified or preserved. Third, burden lies on the center to prove that the relevant material exists to justify the imposition of the President's rule. Thereafter, the court cannot go into the correctness of the material or its adequacy, but it can see whether it is relevant to the action. Only the relevancy could be checked. Thereafter, if the court holds the presidential proclamation to be unconstitutional and invalid, having the power to restore the dismissed state government and revive the state legislative assembly if it was suspended or dissolved. Thereafter, the state legislative assembly should be dissolved only after the parliament has approved the presidential proclamation. Before this, no state assembly could be dissolved. It means president alone could not dissolve the assembly until or unless the parliament authorizes to do so. Until such approval is given, the president can only suspend the assembly. In a case the parliament fails to approve the proclamation, the assembly would get reactivated. It means that until or unless the parliament's approval is given, the assembly could reactivate it again. The secularism is one of the basic features of the constitution. Hence, the state government pursuing the anti-secular politics is liable to action under Article 356. It means center could impose the, you can say, state emergency if the state government is trying to curtail the secularism. The question of the state government losing the confidence of the legislative assembly should be decided on the floor of house, and until that is done, the ministry should not be unseated. Okay. Where a new political party assumes power at the center, it will not have the authority to dismiss ministry formed by other parties in the state. Okay. The power under Article 356 is an exceptional power and should only be used occasionally to meet the requirements of the special situations. It means that it is not a discretionary power. If you are not satisfying, you are feeling that the state government is not feeling as per the standards set by you, then you are not allowed to impose the president rule or the state emergency or the constitutional emergency just by your own discretionary powers. Alright. Thereafter, cases of proper and improper uses. Like, what do you mean by this? Based on the report of the Sarkaria Commission on the Center-State Relations 1988, the Supreme Court in Bombay case 1994 enlisted the situations where the exercise of power under Article 356 could be proper or improper. Like, imposition of president rule in a state would be in proper following situations. First situation is that where after general elections to the assembly, no party secures a majority, that is hung assembly. where the party having the majority in the assembly declines to form a ministry and the governor cannot find a coalition ministry commanding a majority in the assembly. In such case situations, only the president rule could be imposed. Where a ministry resigns after its defeats in the assembly and no other party is willing or able to form a ministry commanding a majority in assembly. Where a constitutional direction of the central government is disregarded by the state government. Internal subversion, where, for example, a government is deliberately acting against the constitution and the law or is formating a violent revolt. Physical breakdown, where the government willfully refuses to discharge its constitutional obligation, and endangering the security of the state. Thereafter, the imposition of the president rule in a state would be improper under the following situation. Where a ministry resigns or is dismissed on losing majority support in the assembly and the governor recommends imposition of president's rule without probing the possibility of forming an alternative ministry. Where the governor makes his own assessment of the support of a ministry in the assembly and recommends imposition of president's rule without allowing the ministry to prove its majority on the floor of the assembly. Where the ruling party enjoying majority support in the assembly suffered a massive defeat in the general elections to the Lok Sabha, such as in 1977 and the 1980. The internal disturbances not amounting to the internal subversion or physical breakdown. So that things were observed during the judicial review and all. Maladministration in the state or allegations of corruption against the ministers, stringent financial exercises of the state. These matters could be imposed where the state government is not given prior warning to rectify itself except in case of extreme urgency leading to the disaster consequences. Where the power is used to sort out intra-party problems of the ruling party or for a purpose extraneous or irrelevant for one for which it has been conferred by the constitution. Okay. After this, now we have the financial emergency. Let's finish it. Grounds of declaration. Article 360 basically powers the financial emergency. Empowers the president to proclaim a financial emergency if he is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened, all over the country or any part. 38th Amendment Act of 1975 made the satisfaction of president is declaring a financial emergency final and conclusive and not questionable in any court on any ground. It means that if the president is satisfied to impose the financial emergency, then he could impose and there is no caution could be raised on the matter in any court. But this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of president is not beyond the judicial review. It means whatever grounds the you can say president use, he has to given it to the court for the judicial review. Parliamentary approval and duration. A proclamation declaring financial emergency must be approved by both the houses of the parliament within 2 months from the date of its issue. Similar like the 356. However, if the proclamation of financial emergency is issued at the time when the Lok Sabha has been dissolved or the dissolution of Lok Sabha take place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first meeting of the Lok Sabha after its reconstitution, provided the Raj Sabha has in the meantime approved it. That is already we had discussed in the previous emergencies. Okay. Once approved by both the houses of parliament, the financial emergency continues indefinitely till it's revoked. It means that there is no time limit on the financial emergency. This implies two things. There is no maximum period prescribed for its operation. Repeated parliamentary approval is not required for its continuation as it required for the other emergencies. Thereafter, a resolution approving the proclamation of national emergency can be passed by either house of parliament only by a simple majority, that is, a majority of the members of that house present and voting. A proclamation of financial emergency may be revoked by the president at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Alright. Thereafter, what are the effects of the financial emergency? The consequences of the proclamation of a financial emergencies are as follows. First, the executive authority of the center extend to the giving of first, the directions of any state to observe such canons of national property as may be specified in the directions. Such other directions to any state as the President may deem necessary and advocate for the purpose. Any such direction may include a provision requiring the reduction of salaries and allowances of all or any class of persons serving in the state, reservation of all money bills or other financial bills for the consideration of the President after they are passed by the legislature of the state. Third, the President may issue directions for the reduction of salaries and allowances of all or any class of persons serving the Union and the judges of the Supreme Court and the High Court if deemed necessary. Okay? Thus, during the operation of a financial emergency, the center acquires full control over the states in the financial matters. And there is a person, H.N. Kunzru, a member of a Constituent Assembly, stated that the financial emergency provisions pose a serious threat to the financial autonomy of the state. Why? Because the center acquires the entire control. Explaining the reason for their inclusion in the Constitution, Dr. B.R. Ambedkar, sir, who was also the drafter of the Constitution, said that this article more or less follows the pattern of what is called the National Recovery Act of the United States, passed in the 1933. So remember this thing, it is important, which gave the President power to make similar provisions in order to remove the difficulties, both economical and financial, that had overtaken the American people as a result of Great Depression. No financial emergency has been declared so far, though there was a financial crisis in the 1991. Some members of the Constituent Assembly criticized the incorporation of emergency provisions in the Constitution on the following grounds. First, the federal character of the Constitution will be destroyed and the Union will become all-powerful. Thereafter, the powers of the state, both the Union and the units, will entirely be concentrated in the hands of the Union executive. Third, the President will become a dictator because he got all the control all over the authorities and the delegations. The financial autonomy of the state will be nullified. The fundamental rights will become meaningless, and as a result, the democratic foundation of the Constitution will be destroyed because all the fundamental rights are suspended except Article 20 and Article 21. Okay. Thus, H.V. Kamath observed that I fear that by this single chapter we are seeking to lay the foundation of totalitarian state, a police state, a state completely opposed to the ideals and the principles that we have held aloft during the last few decades. It means when they were planning to build a constitution. A state where the rights and the liberties of millions of innocent men and women will be in continuous jeopardy. A state where if there will be a peace, it will be the peace of the grave and the void of desert. It will be a day of shame and sorrow when the President makes use of these powers, having no parallel in constitution of the democratic countries of the world. Thereafter, another person whose name was K.T. Shah described them as a chapter of reaction and retrogression. I find one cannot but notice two distinct currents of thought underlying and influencing throughout the provisions of the chapter. First, to arm the center with special powers against the units or the states, to arm the government against the people, like the government could use the arbitrary powers and nothing could be challenged in the court. Looking at all the provisions of this chapter particularly and scrutinizing the powers that have been given in almost every article, it seems to me the name only of liberty or democracy will remain under the Constitution, not on the ground. Okay. Thereafter, T.T. Krishnanamachari feared that by means of these provisions, the President and the executive would be exercising the form of constitutional dictatorship. Because whatsoever they are doing as per the Constitution, and the Constitution empowers this. H.N. Kunzru opined that the emergency financial provisions pose a serious threat to the financial autonomy of the state. We had just discussed. However, there was also protagonist of the emergency provisions in the Constituent Assembly. Thus, Sir Alladi Krishnaswamy Iyer labeled them as the very life breath of the Constitution. Mahabir Tyagi opined that they would work as a safety valve and thereby help in the maintenance of the Constitution. While defending the emergency provisions in the Constituent Assembly, Dr. B.R. Ambedkar also accepted the possibility of their misuse. He observed, I do not altogether deny that there is so possibility of the articles being abused or employed for political purposes because they are coming with very much power. Okay. So students, basically in this lecture, we had finished the emergency provisions. In the next lecture, we will start with something else. Till then, just revise all the facts and figures we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture and thank you.